Good morning, everybody. For those of you in Houston, please be sure to stay safe. Hopefully none of y'all are in that Beaumont area, that cone of uncertainty, but hopefully everybody's doing okay, and just stay safe. We'll give everybody a couple more seconds to come on in, and then we'll get started with our presentation today. So as a friendly reminder, those of you that have attended these before already know this, but this is an accredited presentation, which means you get credit for any of your licenses that you may hold. And the reservation system asked y'all if you wanted credit, so you should be getting some sort of a certificate from us after the presentation. So you get 1 hour of credit for listening to this attorney yap for an hour. Hopefully it's a little bit less than an hour, but we'll see. And I think we'll be able to answer questions as we move through. This presentation is not very slide intensive, but it's discussion intensive. So if you have any questions kind of as we go through this, please type them in. Kyle and Galen are two of our team members who are assisting with this presentation, and they'll be able to kind of interrupt me and ask whatever question y'all have. So with that, let's go ahead and get started. My name's Clint Brown. I'm with the law firm Roberts, Markell, Weinberg, Butler, Haley. I am board certified in community association law and residential real estate by the Texas Board of Legal Specialization. That just means I can get into trouble a little bit easier. And it's supposed to mean I know what I'm talking about most of the time when it comes to those two areas of law. So we're doing our annual checklists. We're coming up to the end of the year. It's always good to burn through these checklists and kind of keep them in the back of your mind. Let's discuss some of our goals. Galen, next slide, please. Perfect. Community amenities, basically not the only parts of the association that require regular maintenance. The association as a non-profit corporation is kind of got a document database that has to be updated every once in a while as well. When I say non-profit corporation, that means that you are bound by Chapter 22 of the Texas Business Organizations Code. And it also means that the money that comes in to the community association goes out of the community association to pay for your vendors and contracts and other items that you're obligated as a board to provide for your community members. Let's go ahead and move on. Perfect, thank you. All right, simple things. Staying informed on case law. Cases come out all the time regarding community associations. Like, I should know, I actually am the editor for the State Bar of Texas's kind of real estate section as it relates to community associations. So I'm tasked with reviewing cases that come in and then issuing case law summaries. So we get interesting cases all the time. And let's talk briefly about one that actually came out last week. Our law firm defended an association up at the Court of Appeals level. So as y'all know, there are really 3 levels for state courts that we deal with. It's the lowest court, which is the district court, and then the middle court, which is your Court of Appeals, and there are a bunch of Court of Appeals throughout the state of Texas, and then the highest court is our Texas Supreme Court. We argued a case on the middle level, the Court of Appeals, regarding the ability to restrict short-term rentals by just adopting a rule. The facts were pretty interesting, but at the end of the day, the court ruled in our favor and said that to a certain extent, you've got some rulemaking authority as it relates to restricting short-term rentals. So very interesting case. And if you're working with us on amending your documents for short-term rentals, all of the attorneys at our firm are aware of that case, and we'll be sure to advise you accordingly. It is a case that uses Chapter 204 of the Texas Property Code, which only applies to certain counties in kind of the Houston Metroplex. Anyways, interesting case. We stayed on top of it. We're aware of it, and all of the attorneys at our firm are aware of that case as well. And we'll advise you accordingly. The other thing to really kind of stay informed of is legislative changes. Our great state of Texas has legislative sessions every odd numbered year. We're in 2020, which means next year is a legislative year. How do you stay informed? Just continue to subscribe to our newsletters, and we provide legislative updates on a monthly basis, or maybe even sooner than that, once the legislative session kind of comes into full swing and you start seeing bills proposed. Easy stuff. Just our newsletter helps with that, and then just making sure you have an attorney who's informed. Looks like we may have a question. What is the case? Does it not pertain to San Antonio? Very good question. It does not. So the immediate applicability, it only applies to the Houston Metroplex area, certain counties over there, because Chapter 204 really governs that. But could it apply to San Antonio? Maybe. There may be a way to expand it, but again, work with your attorney. If your attorney is with our law firm, he or she will know about this case and can kind of give you advice on whether or not we can have that rulemaking authority for short-term rentals. All right, moving on to registered agents. So one of the first things our law firm does when we're retained as counsel for the association, we go to the Texas Comptroller's website and we type in the entity's name. We confirm we're not a robot, and we do a search. And the entity's name should pop up, and it'll tell you whether or not the entity is in good standing to do business in the state of Texas. If you're active and you're in good standing, well then, hey, no problem at all. If, however, you are inactive and you are not in good standing, technically, under the law, that means you cannot do any business in the state of Texas until you fix the problem. What does that mean? That means you technically cannot enter into contracts, you can't hire vendors, you can't collect assessments. It's a road you do not want to walk down. Most of the time going inactive is due to your failure to pay your franchise taxes. Now there's a way to get franchise tax exempt status, but overall, the franchise taxes aren't that much. But please, 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 on a yearly basis, just add a calendar entry for the communities you represent to go to this website and confirm that you are still in active status. Number one. The second thing we do is we look at the registered agent and make sure the registered agent is the same agent that is managing the association, right? The management company. Sometimes the association may shift from management company 1 to management company 2, but fail to update your registered agent information. Why is that important? Let's go through a hypothetical. The association gets sued. Lawsuit gets brought against the association, and the attorney representing the owner who's suing the association does what? They go to the Texas Comptroller's website and they figure out who the registered agent is. They send it to the prior management company and they get served. Now the prior management company is going to be tasked with giving it to the new management company, who is then going to have to notify the association board and the attorney. What does that take? Time. Time we don't have, because you are on a very short clock regarding your ability to respond to a lawsuit. It's the Monday following the expiration of 20 days. Or is it 21? Anyways, short time frame. So we've got to be wary, which means you need to make sure your registered agent information is updated. Now, we've got a nice little website there at the bottom of this PowerPoint for you to kind of cut and paste into your calendar entry for your community so that you check them on a yearly basis. All right, let's move on up. Deeds to common areas. Confirm you have got a copy of all of the deeds regarding the common area or private streets that the association owns. You have to confirm that you are the owner of these common areas. What if you don't have the deeds? What do? Reach out to your counsel. He or she can run what's called a general title report. There's a cost associated with it. It's not that much in the scheme of things. And the attorney should have a title company that basically looks for all documents that are attached to the dirt. And you can even narrow the scope and say, look, I want to look for all deeds for the common areas. Here are the lot and block numbers for the common areas or the private streets. And then the title company should be able to pull those deeds, but make sure you have the deeds, because if the title company pulls one and lo and behold, it is still owned by the developer, that could get you in trouble from an insurance perspective and a liability perspective. So make sure you've got all your deeds so that proper conveyance has occurred from the developer to the association. Now, that applies to single-family residential communities only. Condominiums are different. Condos, you don't really have a deed because the condominium property is owned in common by all of the owners of the condominium community. And it's typically based on the square footage of their unit or just an equal apportionment. For instance, if you had 100 units in a condominium community, and assuming all things being equal, each unit owner would own 1% of the property, capital P property. Each owner would own 1% of the capital P property plus their unit. So you don't really have deeds for condos. This is really for single family and non-condominium townhome associations. All right. Tax bills. So you've got all of your deeds to the common area. Everything's looking good. Next thing you've got to confirm is that you are receiving tax bills for all of your common area, right? You want to make sure the taxing authority is sending the tax bill to the proper person or agent for that matter. How do you do that? You can go into the county appraisal district website and type in the tax number, which you can get by typing in the property address, and then you make sure the tax bill is being sent to the appropriate address. If it's not, you need to talk to the taxing entity, the taxing authority, appraisal district, get that information updated so that you get your tax bills every year. What happens if you don't get your tax bills every year? You don't pay the taxes, right? It's de minimis value. De minimis valuation means the property may be worth $1 million, but because it is owned for the benefit of the community, your nonprofit, that $1 million may get knocked down to $50,000 for fair market, quote unquote fair market. It's kind of a de minimis valuation. So your taxes shouldn't be too much. But unfortunately, we've seen lawsuits where the taxing authority sues the association for non-payment of taxes. And what is their remedy? Well, much like a community association, their remedy is foreclosure of the common area that has not paid the taxes. So again, road we don't want to walk down, so make sure all the tax bills are being sent to the proper address. Doesn't apply to condominiums. Okay. Corporate status. So this is similar to kind of searching the entity. You use the same website, state comptroller's website. One thing you can look at is, are you franchise tax exempt? If the answer is no, you should be able to. It'll save you a little bit of money every year. Franchise taxes really aren't that much, especially for nonprofits. But if you want to save that money, then again, work with your counsel, management. Y'all may be able to do it with the accountant, kind of get assistance that way so you don't have to get counsel involved. But yeah, there is a way to become franchise tax exempt, not sales tax exempt. That's a different question. It's franchise tax exempt. We've got some questions here before we move on. Co-op. Is there a deed? Co-op. I think there's only one co-op, or well, maybe two or three in the state of Texas. Cooperatives. Diana, I'm sorry. That is a good question. I'd have to look at our co-op code in the Texas Property Code to confirm. I want to say the answer is no. Miss Becker, Ginger, hey, I haven't spoken with you in a while. Ginger, I hope all is well. You're doing good. But yes, Ginger makes a very good point. The deeds are applicable for commercial associations as well. So absolutely, Ginger's right. Yes, deeds are applicable for community or commercial associations. Next one, Jamie Patterson, is that same for all HOAs still under developer control? So, good question. And when the developer first kind of builds the community, right, the common area and all the property is under the developer's name. As the developer builds out various sections in the community, they will start to convey the property from the developer to the association. So the conveyance kind of happens as you go through time. So it's not an all at once thing usually. It is usually done by section. So Jamie, the answer is it happens as the community gets built. The problem is that sometimes common areas slip through the cracks and the developer forgets to convey it. That's why it's important to make sure you've got a good laundry list of the common areas so that you know that conveyances have occurred properly. Another question from Katrina Swindle. The tax bill is for single family only, not condo, since they have no deeded property owned by the association, correct? Absolutely, Katrina, you are right. Again, tax bills apply to single family communities, non-condo townhome communities, and commercial communities, to Ginger's point. And the other thing to think about, so condominiums, if the association isn't paying the tax bill, who is? Who do you think, right? The unit owners are. So that valuation kind of gets filtered down to the unit owners so that they have to pay that additional tax to kind of make up for the money they're losing from the condominium association. So the tax man cometh in one way, shape, or form. All right, Diana, yep, she followed up. I figured you're down in San Antonio. Y'all are the only co-op in Texas. And Diana, I would say I'd probably have to look at your governing documents, your declaration to confirm in terms of ownership of certain common areas. But good question. We can definitely take it offline. I'm happy to take a peek at that if you want to send me an email. Okay, those are our questions so far. Let's keep moving. Thank you, Galen. All right, management certificates, are they up to date? What's the big deal, right? What's the big deal about updating our management certificate if we go from management company 1 to management company number 2? Here's the problem. A unit owner or a lot owner wants to sell their property. They get a title company involved. What does the title company do? What is one of their processes that they kind of get initiated? It's requesting a resale certificate, right? A resale certificate has got a bunch of information, what's the deed restriction violation history, budgets, all of what's the amount due and owing on the account. A bunch of different items are found within the resale certificate. Well, where does the title company get the name and address and website for contacting the association about getting the resale certificate? Through the management certificate. So that if a management certificate has not been filed or has not been properly updated and the property sells without a resale certificate, even though the title company tried to get one, all the money due and owing against the property gets wiped. New owner's not obligated to pay, number one. Number two, the deed restrictions that were existing on the property get wiped, completely wiped out, so that the new owner gets a windfall as it relates to any violations that may have been attached to the property. There's a time limit for management certificates. You've got roughly, I believe it's 30 days. And again, different sections of the property code apply for single family. Single family is chapter 207 of the Texas Property Code, whereas condominiums, you can find it in chapter 82 of the Texas Property Code. So there's a clock ticking to get it updated when a new management company comes on. That's why it's so important to either do it yourself. Some management companies do it internally. Other management companies get counsel to do it. If you are going to do it internally, just be careful. We run into mistakes all the time we see with management companies. Do not attach any governing documents to the management certificate. That is not a proper way to file a document. Please, please, please do not do it. We run into those issues a bunch, and it is not a properly filed document. And you may get into noticing issues for your owners. But here's what you've got to provide. It's just a laundry list, 1 through 7. Make sure you've got all of this properly input so that you don't get in trouble and they contact you properly for the management certificate. Because let's say you're still previous management company management certificate, so they send the request to the previous management company. Previous management company has to take it, then they've got to do research. Oh, we don't represent this entity anymore. We think it's this one. Then they send it to somebody who may not be the resale certificate department, and then it gets passed around, and lo and behold, maybe you miss the closing. So again, make sure the management certificate is up to date. All right, we've got some questions popping up from Ms. Swindle. Do management certificates have to be signed by the board, or can the management company sign it? Let's see. I think single family is agent, and condominium is board. So it depends on what kind of community you are dealing with, Katrina. Very good question, though. Pretty sure I got that answer right. Yeah, single family should be the agent, the management company, and then condo is board. I'm fairly certain that is the correct answer. Don't hold me to it, Katrina. Jessica Ramirez, how often does the management certificate need to be filed if the management company has not changed? So, look, as long as nothing's changed and you don't have to update any of the 1 through 7, then you're good. The management certificate's on file, you're good. But if one of these 1 through 7 changes, let's say you amend your declaration, then you need to update the management certificate, obviously. But otherwise, as long as everything's looking good, your address is all good, then the management company certificate, the management certificate you have on file is good. And let's see, I think that's it. Katrina, you're welcome. Let's move on to the next one, Galen. Thank you. Just do it. Just do it, guys. Read your dedicatory instruments, right? They're wonderful. They're such a great read, right? Something you want to read. Keep it on your nightstand. Read them before you go to bed. And for the managers out there that manage 7, 8, 9, 10, 12 communities, that's not that much paper to read through, right? No, look, I get it. It's a very big task. But do your best to keep up to snuff on your dedicatory instruments and what they allow you to do and don't allow you to do. They're really important. And, you having at least a base knowledge on your governing documents and how they operate are really going to help you in managing your communities. You're going to be able to answer your questions that much quicker, do your searches that much quicker so that you can get answers to your board that much quicker. So it's good to keep up to snuff on your governing documents, number one. Number two, if your dedicatory instruments are not filed of record, this is for condominiums, single family, and non-townhome associations single or non-condominium townhome associations. So all of the above, if they are not recorded in the real property records, they are not enforceable. So make sure you get them recorded in the real property records where the property is located, in the county where the property is located. Because if you don't, they are not enforceable. What is a dedicatory instrument? It's your governing documents, right? It's your articles of incorporation or certificate of formation. It's your bylaws. It's your declaration. It's your rules and regulations. It's your design guidelines. It's the policies you've got to adopt to comply with statutory schemes and different changes in framework. All of that stuff, those are dedicatory instruments. If it's something you want to enforce, it needs to be recorded in the real property records. One thing that always gets a lot of associations are pool rules. You'll find that many pool rules are not recorded, but they're posted on as signage in the pool area. Well, it's not recorded, but it's a rule you want to enforce. You better get it recorded. All right, let's move on. Is it time? Oh, it looks like we may have a question here before we move on. Okay, keep in mind that townhomes can be single family or a condo, as the legal description can be different than the physical description. Our community is a fee simple townhome community, and we have the management company complete the resale certificates, etc. So, Ms. Busby, yes, good point. The townhome, it's all about how the governing documents are written. Nowadays, you've got to include condominium if you're a post-94 condo, but pre-94, you could have called your entity townhome and be a condo. So for the older townhome communities, you've got to look at your declaration to determine if you are a true townhome community, single family, or if you're a townhome community condominium. So it's very important to distinguish that because different rules and regs apply. Again, your counsel should be able to assist with that if your manager cannot or you've got questions surrounding it. From Ms. Brown, Natasha, is there a checklist or cheat sheet we could use for key items in the dedicatory instruments we should know? Something we could fill in as a quick reference guide. Natasha, there's not a cheat sheet per se, but the big items, you've got deed restriction enforcement, number one, and then you've got your collections, number two. For collections, I think it'd be a little bit easier to come up with a cheat sheet. What is the interest? Can you levy late fees? And if you can, are they secured? Can you levy fines? And if you can, are they secured? And is there any kind of cap on your ability to increase assessments? Those items are all very important to keep in mind. And I think you could maybe develop a quote unquote cheat sheet. I know that internally many management companies have a good system in place that their transition team utilizes. So when a new association is getting onboarded with a community, basically they've got an internal process and they've got a lot of data fields that they enter with that kind of information. So you should already have kind of a little bit of a cheat sheet, at least as it relates to collections. Unfortunately, with kind of deed restrictions enforcing them, it varies from community to community. All right, let's keep on moving. Let's see. Oh, can you go back, Galen? Thank you. Knowing when you need approval of the members to amend the document. Okay, so amendment provisions. Let's do the articles of incorporation. It requires member approval, and your articles really typically control the percentage. Next document we'll discuss your declaration, your CC&Rs, your covenants, conditions, and restrictions, your deed restrictions. All those terms of art basically define your declaration or deed restrictions. And for deed restrictions, it is called the ceiling rule and the floor rule. So ceiling rule, floor rule. Single family and non-condo townhomes, ceiling. Condominiums, floor rule. So again, single family townhome, think of a home, you know, a standalone. It's the ceiling rule. So let's go with the ceiling rule first. Magic number, 67% of all owners or lots, however the declaration is worded, and 67% is our ceiling. So if the documents say 70%, well, we can't go above the ceiling, right? The ceiling's as high as you can go in a house, so it gets dropped down to 67. Same hypothetical, but the document says 50% to amend the declaration. Well, we're only dealing with a ceiling rule, so 50% would control. So you would only need 50% of the owners to amend your declaration. So ceiling rule, single family and non-condo townhomes. Floor rule, okay. So 67% is our floor. If the condo docs say you need 70% to amend the declaration, well, guess what? It's above the floor, right? That means it's 70%. It is okay for it to require that. Same hypothetical, it drops to 50%. Well, our floor is 67%. You can't go any lower than the floor, so that 50% would get bumped up to 67%. So that's kind of a little cheat sheet item to think about for your declaration. Moving on to your bylaws, it really depends on how the bylaws are worded and applicability of state law, because the board may be able to amend the bylaws regardless of what the bylaws say. If you're a single family non-condo townhome, then you would potentially be able to rely on section 22.102 of the Texas Business Organizations Code. And if you are a condominium, you would potentially be able to rely on that section 22.102 and 82.102 of the Texas Property Code to allow for the board without a member vote to amend their bylaws. A lot more nuances I'm not going to go into. The important thing to remember is the board may be able to do it and to get with your council to determine what the standard is. And then rules and policies and all that good stuff, the board implements those and amends, repeals, and changes those. It's typical board function. Which rules and policies are required by legislation versus recommended by your council? Again, if you're a community that hasn't really had general counsel before and you need a lot of assistance, that's one thing you need to get your attorney to do. There is a checklist that we have for governing documents. So it's not a checklist cheat sheet, but it's a checklist we go through to make sure all of the legislatively required policies have been adopted. And if they haven't, we note it to our new community. And then we note also the policies that the attorney that we recommend as a law firm as well. So again, make sure you're getting with your counsel. Maybe you've already gotten that taken care of as a result of 11, 13, 15, and 17 legislative changes. But if you haven't, make sure you get with your counsel so that he or she can provide you with that laundry list. Next slide, Galen. Thank you. Looks like we may. Do we have a question? Okay. No questions. No questions. All right. And here's kind of what we just talked about: the ceiling rule, floor rule. Articles of Inc. is typically 2/3 of all members. Guidelines, rules, and regs. Okay, we can go on to the next slide. Mandatory policies for homeowners associations. So homeowner associations, sorry. So that's single family and non-condominium townhomes. You need a records and copying policy, a payment plan policy, and a records retention policy. What is a records and copying policy? Well, if Bob wants 5,000 pages of association documents and he makes a request, if you've got a records and copying policy in place that complies with Chapter 209 of the Texas Property Code, you get to cost shift from the association to the owner and say, well, Bob, we got your request. we've got the documents, we can provide them, but you have to pay us 10 cents a page for 5,000 plus $15 an hour for however many hours it takes my manager to locate, compile, and reproduce the records. And then there is an overhead fee of, I believe it's 20% you can levy on top of all that as well. And Bob, guess what? You have to pay that money before the association undertakes the records request. It puts the owner in check. Look, the owner's entitled to the records. You're a nonprofit. You're supposed to be transparent. But the association doesn't have to bear 100% of that cost. They can shift some of that cost burden over to the owner. So it's really helpful to have that records and copying policy in place. If you're a condominium, they're not required, but hey, I recommend getting one and putting it in place, right? Borrowing from Chapter 209 so that you can burden shift. Because if not, it's technically, you know, I think you can charge them under 82, but it's not as good of a process that's been laid out. So we like to follow 209. Payment plan policies are required, and then again, a records retention policy is required, telling us how long we should retain records. Now, keep in mind, once you adopt that records retention policy, you've got to be sure to comply with it, right? So once you hit the limit of whatever the retention is, you need to destroy the documents. You don't need to keep them on in perpetuity. Get rid of them in accordance with your records policy. Next slide. Let's see, do we have any questions? No questions. Policies recommended. Oh, nice laundry list. Attorneys like their policies, right? We find that it does help, absolutely. Just laundry list, flags, flagpoles, political signage policies, all that good stuff is just some good things to keep in mind. If y'all see any policies on here that you really want to chat about, we can chat about them. Otherwise, I'm not going to go into too much detail on them. Let's go to the next slide. Some more. Leasing policy, common area policy. Oh, here's a good one for condominium associations. It's called an insurance allocation policy. And it allows the association to kind of dictate how that insurance deductible that you've got to pay, and many times it's very large when some sort of an event happens, how that gets paid between the association and certain owners. You may be able to shift the deductible payment obligation over to the owner. So it's important you have that insurance allocation deductible policy in place. Okay, let's see, do we have, we've got a question here. How about a social media policy from Lori Jo Ball? Yes, ma'am, very important to have one. Geez, social media. No fun. It's here to stay. And look, sometimes owners can get really, really nasty on social media. And unfortunately, sometimes board members respond on social media, make comments on social media when they shouldn't. So yeah, it's important to have a social media policy in place and then enforce that social media policy accordingly. Absolutely agree. Cindy, HOAs can have a leasing policy that restricts. I'm thinking you have a ... afterwards. If you're a condominium, you've got a little bit more leeway to make your leasing policy more robust. If you're a single family or non-condominium townhome, you are limited a little bit more. But again, that case I mentioned earlier may give us a little bit more latitude depending on where the association is located. So for leasing policies, make sure you get with your counsel. He or she's going to be able to help, and it really is dependent on the type of community you're dealing with. Is there a sample board code of conduct policy? Jamie, there is not. It really depends on the community's needs and wants and how your bylaws are structured. Of course, there are some basics that you want to include in your code of conduct, but many times the code is aspirational in nature. It is a I promise to do right type of document that you implement. And there really is no cookie cutter. It depends on the board's needs and functions. But very, very good question. Crystal Avendano, how do we know if condos can have electronic annual meetings? Oh, Crystal, virtual meetings. So as it relates to the virtual meeting, Texas Business Organizations Code 22.002, I believe is the proper section, gives you clear authority to have a virtual meeting of the members, to have one. Virtual voting is the other kind of sticky area we've got to get into for condos. And unless your document's very clear allowing for different voting methods, you've got to amend your bylaws to allow for virtual voting, right? So you may have to amend your documents depending on the age of the condominium. Single family and townhome communities, you've got a lot more latitude, and many times you don't have to amend your bylaws at all, because 209 gives a lot of rights for holding virtual meetings and online voting. So very good question. And let's see here. CAI has a nice reference for board code of conduct. Yeah, so that's a good point. CAI has got kind of a national board 101 type webinar that you can participate, and they've got documents that you can get from them, and one of those kind of guides is a code of conduct. Keep in mind that it's more of a national type code of conduct. It's not state specific. So it's again, it still has to be changed so that you're pulling in Texas law. But very, very good point. CAI is a wonderful reference tool. Community Association Institute is a wonderful reference tool for managers and board members. So good question. Okay, I think that's all of our Q&A so far. So again, let's keep going. Next slide. Single family policies kind of recommended. Sidewalk repair policies, depending on whether or not it's an owner responsible item or association responsible item. Exterior home video surveillance camera policy. That's a long policy name, isn't it? Well, if you run into issues with surveillance cameras in your community, it's probably a good idea maybe to get a policy in place so that you establish some good guidance for your architectural committee in approving or rejecting those type of devices. And, we also want a nice disclaimer that, hey, we're not providing any kind of safety, health, anything like that for your installation of the security cameras. Gate fee policies, we don't run into those too terribly often, but some communities need that in place if you're a community that has a lot of events. And we've got a lot of communities that are heavy on events. Solicitation of candidate policy. So Chapter 209 of the Texas Property Code, which applies to single family communities and non-condo communities, has solicitation requirements for communities that have more than 100 lots. And again, it may be a good idea to have a policy in place to kind of provide some guidance for your boards moving forward. It's really not required, but it's something interesting that you want to think about. Next slide. All right, geez, so many policies. Just keep going through them over and over again. Insurance deductible policy, we already discussed that. Maintenance matrix, a responsibility matrix. So picture a table, 2 columns, or actually 3 columns. One column is the description of the item. Another column is whether it's association responsible, and then the third column is whether it's owner responsible. So you go through various hot button topics and you just do an X or check mark to determine whether it's association or owner responsible. It's a wonderful tool. It's a table. We like to add a disclaimer that in the event the table conflicts with the declaration controls, but it basically provides a good guidebook for the board, the manager, and for your owners. So yeah, responsibility matrices are great. Again, just other items here. We've got a question. Can owners video out their windows to capture common areas? If not illegal, can the board put in a policy for this? Video out of their windows to capture common areas. I don't know that that would be illegal. Can we put a policy in regulating it? Potentially, and it really does depend on how your governing documents are worded. But I'll say if the video is only capturing the common areas and isn't capturing, right, the neighbor's window zoomed in, then there is really not an expectation of privacy for the owners who are traversing on the common area. So there may not be much we can do, but I think that's a good question, and the governing documents would have to be looked at. All right, next slide, Kaylin. Perfect. Hey, we made it to the end. We've got roughly 10 minutes left. Organized, well thought out policies really do assist the association. Again, we don't need to get 50 policies on the books, but when you know there are going to be issues and concerns the community's going to have to deal with, it really is a good idea to get policies in place, number one. Number two, when you're enacting a policy to comply with a state law change, I think those are huge. Why are they so important? Let's take solar panels, for instance. Some of our documents that were created prior to legislative changes in 2011, 13, 15 sessions, we've got restrictions in there that say no satellite or no solar panels, excuse me. Board, the year that the solar panel requirements come out, they may be aware, oh, we've got to allow solar panels now by law. What happens 5 boards down the road who don't know anything about that solar panel law? If you don't have a policy in place, they may forget, and the board or ACC may deny a solar panel request in violation of state law. That's why it's important to take the state law and create a policy that addresses it so that you don't run into those kind of issues. Review your governing documents periodically, never less than every legislative session. Again, if you subscribe to our newsletter, you're going to be getting great legislative updates so that you can stay up to snuff on any kind of law changes. At the end of the legislative session, we also give a great article that kind of details what kind of policies you need to adopt. So again, all good information. As long as you're subscribed, you'll be getting that next year. Periodic tune-ups, cut and paste jobs. Don't cut and paste from other associations. Number one, if it's copyrighted by the attorney that drafted it, well, that's copyright infringement, right? Get you in trouble. But number two, many times the policies and rules, regs, and declaration provisions were created specific to that community. If you start cut and pasting that kind of stuff, you're going to create some conflicts amongst the governing documents, which is a big no-no, because why? It leads to confusion amongst the members and potential litigation down the road. So try to avoid those cut and paste jobs as much as you can. And with that, let's see, we can open it up to more Q&A. We've got one here regarding management certificates. If you recognize that you do not have one in place, but have been the agent for over 30 days, can you still record one? Absolutely. Great question. Get it done just as soon as you can. Look, if you don't meet the deadline, that's okay. Get it done. Get it updated. And you know, I'm gonna look up 2072. Do we have any other questions from anybody? No? All right. Thank you all so much for having me here today. And I hope y'all learned a little bit. Again, plenty of time to reach out to me if you have any questions. I'm always happy to allow you to bend an ear. As my saying goes, though, you get what you pay for, right? It's sometimes important to really get a good formal attorney opinion on some of the big ticket items. But again, always happy to listen and provide my 2 cents. And I think that's it. Well, hey, y'all enjoy the rest of the day. And look, if y'all are in the Houston area, please, please, please be safe. hunker down, and I'll be thinking about y'all. Our whole law firm is really thinking about everybody who's about to be affected by this hurricane. So y'all be safe, and we will be in touch. Bye, everybody.